that's why I have sympathy.
Good afternoon. I had planned to say good morning, but we're well into afternoon now.
Yes, we are.
May it please the court, my name is Dwayne Diker.
The last case of the day.
Yes. My name is Dwayne Diker. Together with my partner Jared Malone, we represent the appellant Douglas Bagge. I would like to reserve 5 minutes for rebuttal.
Thank you, sir.
The circuit court erred as a matter of law in granting summary judgment and interpreting Mr. Bagge's residual disability policy with reference to requirements that were outside the four corners of that policy and contrary to the plain meaning of the policy that was marketed to him and that was sold to him. This is really a case that's about the policy language. It's uncontested that Mr. Bagge had a total disability relating to a major depressive disorder that caused him to lose his job. He had a 100% loss of income in November of 2010 that is continuing. And we would say, based on the definition of residual disability found in the residual disability rider, which I'm sure the court is familiar is in tab 5 of the appendix, page 90 of the record, that he has met the requirements for residual disability benefits. Now, it's also uncontested and in fact conceded that Mr. Bagge is able to return to work. That was a concession that was made when the trial judge was prepared to have a jury trial on that issue in order to streamline the case so as to not have a jury trial over an issue that we believed was irrelevant and not necessary to the case. We stipulated to that fact. New York Life's argument in this case is really about, they are saying that residual disability is all about work capacity of the insured to work. And their argument starts to sound like everybody knows, right? Everybody knows that you have to work in order to collect residual disability benefits, and certainly there are policies that say that. But our point is that is not the policy that New York Life sold to Mr. Bagge. There are a lot of arguments in this case about what does residual disability, what does it mean, what are the incentives supposed to be, and New York Life talks about all those things without really referencing the language of their own policy. And to be certain, there are policies differ between companies, and even New York Life's own policies differ. The record will show that in 1986, when Mr. Bagge was shopping for a disability policy, he was shown 4 different versions of a policy with varying degrees of residual disability coverage. 2 of them had some requirement that he would have to be working as gainfully employed in order to recover. One of them had required an ongoing physical impairment, but waived the gainful employment requirement. And ultimately, the product that he purchased, the 4th of those, made no reference to either requirement. That, in fact, there is marketing materials that he was given in the record that show that New York Life said, well, those requirements have been eliminated from this policy. That's the policy that he purchased. So a lot of the arguments that we hear in the briefs about the policy, I think New York Life is referring to a policy that they would have preferred to have sold, but not the policy that they actually sold.
So under this, I'm sorry, go ahead. You first, you're a senior.
Gosh, I'm getting older, also. So there's a difference between what the contract said, which you mentioned before, this is a contract language case, and was represented to be, then if there is a difference, then there may be a misrepresentation or fraud in the inducement type case, as distinguished from our interpretation of the language that appears.
That's right.
Yeah, if I understand your argument, we should look to the language of the contract.
We're relying on the plain language of the contract. That is our.
The rider has both the total disability and the residual disability, and I hope I've used the words correctly.
Well, the policy has the total disability provisions. There's a rider with the residual disability.
Correct. I'm sorry. Are they 2 separate provisions, or are you arguing in your brief that they are not? They are interlocked. I think that was the word used. So they are basically one continuation after the other. I'm trying to make sure I don't make the wrong argument. Understand the wrong argument. I want to make, so that's kind of where I'm at right now.
Right. I want to make sure I answer your question.
Yeah.
So that the rider modifies the existing policy so that it is effectively one policy with two different layers of interlocking coverages that are designed to protect the insured in different circumstances.
And as I understand the operation of that policy, if you are receiving benefits for total disability, you are not eligible to get benefits for residual disability. That and age 65, I think, were the two. Is that right?
That is correct.
Okay. Your turn.
So my question.
Right.
So under this New York Life policy, as distinguished from others, your position is that your client and others similarly situated to him would not have to go to work to get this residual benefit. There would be some determination about what percentage of his ability to work has been impaired by his disability, and that he would be able to receive that check while not going to work anywhere.
That is correct.
Okay.
That's correct.
And that obviously sticks in. They're having a hard time with that because that's not normally how these work.
Right, it clearly does, and I think that, you know, the thrust of the argument, it's not expressly said, but the thrust of the argument is that they are implying that Mr. Bagge has somehow hit the jackpot in this case, right? That he, after paying disability insurance premiums for 23 years, after suffering a major depressive disorder, after losing his career as a corporate attorney, and now 7 years of litigation with his insurance company, the jackpot at the end of the rainbow is he might be entitled to $1,800 a month in a full residual disability benefit, which is about 12% of what he was earning pre-disability. So I think that's important to keep in context. I think that they are, there's some implication that this is outrageous, you know, that this type of coverage doesn't exist, and clearly it does exist. New York Life was marketing it and selling it.
But the question really is, what does their policy say?
Agreed.
At the end of the day, that's really what we're here about, right?
Yes, agreed. They are also sort of, New York Life is backed into a little bit of a corner in this case on the policy interpretation issues. Ostensibly, they are arguing for the clear meaning of the language in their policy. That's how their argument starts in their brief. But they can't get where they want to get with the clear language in the policy. So then we start having arguments about, you know, what does residual disability mean, references to other cases, no Florida cases, but other cases as to, you know, this supposed overarching understanding that people have to work to get residual disability benefits. The problem with that is, in order to loop that into their argument, they really have to be arguing that the policy is ambiguous. You can't bring in these other aids to interpretation if the policy is not ambiguous. The problem, and the reason they don't want to do that, is because of the weight of Florida law says ambiguities in insurance policies are interpreted strictly against the insurer, liberally in favor of the insured, to maximize coverage. So they are sort of in a catch-22 here, where the plain language doesn't get them where they need to go, but I don't think that they want to characterize the policy as ambiguous either, because then they have a very difficult time with those presumptions.
Obviously, I've not spent anywhere near the time in this case as you have, and you've just withstood a double teaming, but I'm coming back. I want to ask you a question.
That's right.
Assume, I'm not asking you to conceding, but assume the residual disability is a separate coverage. Do you have to apply for that again? In other words, normally when you apply for a benefit, you submit, as you did in this case, an application. There's an investigatory period, and I think there's some sort of period in the contract that talks about paying premiums and stuff. Would you be required to apply for that?
I don't think so,
Okay.
Not the way the policies interlock. Right. The basis for the summary judgment, the trial court's basis for the summary judgment was that Mr. Bagge was able to return to work. That was the fact that he stipulated to, and that was the fact that the summary judgment turned on. And I would suggest to the court that there really is no policy language that suggests that that is a factor in making him not eligible. In fact, the way the policy works, total disability kicks in when you can't work at all. Residual disability is payable after you can return to work if there is some loss of income. So we would suggest it doesn't make sense that the ability to return to work could be a disqualifying factor. And in fact, New York Life really isn't even arguing that on appeal in support of the judgment. What they are arguing, they have two arguments that they're making. They're both new arguments to this appeal. The first is that they're arguing that it's this must-work argument, that Mr. Bagge must work in order to be eligible for the residual disability benefits. Again, I would just say that that language is not in the policy. It's in other policies, but it's not in this one. And I think that you can see this very clearly in the answer brief, that New York Life bases their entire argument on a concept that is not in the language. And I'm going to quote just briefly from page 15 of the answer brief. The crux of the argument is they say that residual disability is designed to protect the insured whose employment earnings are negatively impacted by injury or sickness. And that does sound like you have to return to work. The problem with that is that none of that language is in the policy. The policy doesn't talk about employment earnings. It doesn't talk about a negative impact. It talks about loss of income. The other language, this implication that that's what the policy was designed to do, is simply not in the policy. New York Life is also arguing that there is this 90-day periodic reevaluation required. Again, this is an argument as is first appearing now in support of the summary judgment. They contend that they have the right to periodically evaluate the causation of the claim every 90 days. And they say this, they reach this by reading the policy together, reading the provisions together through the lens of this overarching belief, what the purpose of residual disability benefits is. In fact, this 90-day language, the only place the 90-day language appears in the policy is in the initial time period to provide written proof of a claim. It's under the claim section of the policy. It's page 84 of the record. Now, the policy does, a couple pages later, go on to give the insurer a periodic right to audit financial statements, financial documents to verify the loss of income, because Judge Castaneda, like you were saying, there is a continuing look at income over time. But there's nothing in the policy that supports a truncation of the benefits period into 90 days. The 90 days was simply lifted from another unrelated provision. Furthermore, it doesn't really make any sense. If the initial triggering event that caused the total disability is not enough to sustain residual disability, it would essentially never be paid, right? Because after maybe the disability ends within the 60-day elimination period, or maybe it doesn't, you would certainly never get more than 90 days of residual disability, because if you evaluate in the way New York Life suggests, the cause of not having income in any subsequent period is always that you didn't get a job. That's not what the policy means. The loss of income was the original disability which caused the loss of his job and his career. I wanted to just briefly address this invited error issue because it's raised in the brief. Respectfully, I think that New York Life is misunderstanding the doctrine of invited error in this context. Clearly, an appellant cannot invite a trial court to make a ruling and then challenge that very same ruling. It's inefficient, it's unfair. What happened here is that Mr. Bagge stipulated to a fact his ability to return to work. The circuit court applied that fact to its interpretation of the policy language, and they reached a conclusion as a matter of law. The fact that Mr. Bagge may have approved the form of the order isn't relevant. He isn't challenging, he is challenging the court's interpretation of the policy, and he stands behind that factual stipulation 100%. He is not backing away from that. This was his attempt to streamline the case to get past an issue that we believe was not relevant. If we are wrong as a matter of law and that turns out to be a key fact that supports the court's judgment, then so be it. But we certainly have not invited the error. What we have done is set this case up in a way that this court can now review it with stipulated facts, de novo, as a matter of law, and make a determination.
You have 40 seconds left.
Okay,
to get to 15.
all right. I will save that for rebuttal then.
All right.
Thank you.
Thank you, Your Honors. May it please the Court, my name is Jerry Tolton, here on behalf of New York Life for purposes of the appeal. I just want to say briefly, I disagree with the proposition that the policy does not speak to the issue that we have. I think that if you read the policy in its entirety, which Florida law says we must, these policies are designed to protect an insured who has a loss of work capacity, or when they regain work capacity, protects their income if their medical condition continues to impact their condition.
Some cases I have read have indicated that the purpose of a disability problem is to replace income. The purpose of disability insurance policy is to replace income loss when the insured becomes disabled while engaged in a regular occupation. And arguably, he was engaged as an irregular occupation as an attorney and became disabled. So if this is a disability problem to replace his income.
Well, I think it's a mind bender, Your Honor. But the problem we've got with this case is that he says I'm no longer disabled. He says I can return to work.
Go back to work, right?
That's
not
right.
necessarily saying he's not disabled.
I would respectfully disagree. He had a claim in his complaint for total disability, which he dropped. He voluntarily dismissed that. He is no longer saying he's disabled. He's saying I can go back to work. The only medical condition that's ever been at issue in this case is major depressive disorder, and that has always, in his life, in his personal circumstance, has always been a waxing and waning phenomenon, which it is medically. In his case, it tends to last from anywhere from 4 to 15 days, but in this case, it lasted a little bit longer. He was paid for that period of time. But when he says my major, which he stipulated to, it's in the record, when he says my major depressive disorder no longer prevents me from returning to work, I don't know how else to construe that other than he is no longer disabled. He can go back to work. It's a work capacity question.
Theoretically, one could work as an associate rather than the lead counsel, where stress is lesser. I remember when I was an associate, I thought my level of stress was high until I realized when I became partner, there was income had to come in to pay all the subordinates. So perhaps in his job, that's the same thing. My concern is he filed an application in the beginning. Mm-hmm. You have an opportunity, your clients do, to investigate the claim, to decide whether it's proper to be paid. And he asked for both a permanent disability or total disability and residual. The latter was denied. The former was granted for a specified period of time. Some of the cases suggest that the residual that you get on a rider is a separate policy provision to provide an income stream, if you will, but does it not require an application? Because you would then get an opportunity to review the application, to find out what the level of work is, to find out what the level of his claimed disability is and what level. And as I go through this record, I could only find the initial one and no one from either side saying that this is required. And I know there's argument about interlocked, and I don't want to inject something into your case that you're all both well familiar with, but coming from the outside, and I'm looking at this forest of trees that I don't deal with every day as you all do, why would he not be, if this is a separate benefit, required to file a separate application, require the insurance company to have their their contractual rights to investigate the claim and then pass upon it?
I think that's absolutely correct. I think they should have.
Why didn't it happen?
I don't know. I think my answer would be is because he thought he was totally disabled. My answer would be, and you remember, let's go back and look at the facts of how this all boiled down. He takes a new job over in West Palm Beach as a corporate counsel. Let me just. Yeah. He takes that new job. He's there for about 3 weeks. He has an episode of depression. He then leaves that job. He resigns. He gets treatment. He then decides he wants to. Now, mind you, he never files a claim. So we're in October of 2010, November of 2010.
That's a great period of time.
15 months. 15 months. He asked for claim forms. He never submits them. And the reason he never submits them is he wants to go back to work. He has this work capacity. But, Your Honor, to get to your larger question, I think, you've got to be able to apprise the insurance company of the claim you're making. Number one, he made a claim for total disability benefits. And number two, if you're going to claim that you're residually disabled, you have to at least substantiate that your residual disability continues to be, a medical condition continues to be the cause of your loss. It's not a one-time fits-all situation. It doesn't get fixed on October the 30th, 2010, and that's it.
You said I was right in your, where in your policy would I find that he would require, that you would say that the meaning of the paragraphs say that you have to file a separate application for residual disability?
Well, I think because if you look at the rider, Your Honor, it talks about all of the financial auditing that goes through there, and that would be where I would turn your attention to.
New period of disability, would I look at that? I'm trying to figure out, this is the contract between the parties, and if you think my theory is correct, where does the contract say that? Because we all know that we are limited to what you have written, that this court can't write the policy for you.
Well, I would suggest it would be under the new period of disability. If the insured recovers from a disability for which monthly income was paid, any later period of disability will be treated as a new period of disability. And then that it goes on and talks about what that means. But you know, Your Honor, look, let me ask the court if it would to look at the rider on the second column under the modification of policy provisions. This is under the paragraph 3, actually boils over into the second column, and it basically talks about when the monthly income benefit for residual disability is payable. And one of the things it says there is this benefit is payable at monthly intervals every 30 days during the benefit term. During the benefit term. So what does that mean? What is a benefit term? Go to the policy definitions. The policy definition of benefit term. A period of time for which monthly income benefits are payable for disability due to the same cause. It starts on the day after the elimination period ends, which is 60 days in this policy. It goes on until the insured is no longer disabled. And I guess I don't want to get too much into semantics, but I don't know of a single case in Florida or in the United States that says when an insured can go back to work, he remains disabled. When he can return to his work, he remains disabled. If that was such an obvious proposition, I'm sure they would give you a case for that.
Would that be a defense to his claim that I am residually disabled and I can't go back to work full time, so I'll take the minimum payment, and you would say, yeah, you are capable of earning more, and therefore your claim is denied? Is that part of the process? I mean, because in this case, he has not gone back to work, and his claim is, I think I'm disabled, I only want my residual benefits. The argument they're saying is that it just logically flows from the beginning, and that's part of I think the concern that everyone's having, that whether or not these are interlocked, that they flow one another, or they are separate policy provisions providing separate benefits at certain times following an application.
Yeah, and they're not. I do think that's right. I think they're looking at it as if it was two contracts, and you have to look at it as it's one policy, and it doesn't make sense to read it as two contracts.
Exclusive terms, though, aren't they?
They are mutually exclusive terms. You cannot be residually disabled and totally disabled at the same time.
So there's two separate provisions. They can't apply at the same time, even though it's one policy. They've got to be evaluated separately, one after the other.
Right, right. And their argument has always been, and they seem to have, it was a little quieter there, but their argument has always been that because he initially went out on November 1, 2010, that's all he needs to do. He doesn't need to do anything else. He doesn't need to substantiate a continuing disability.
Off on a summary judgment.
Well, a summary judgment that he stipulated, that he actually wrote and gave to the court.
So, okay, so that's really not an issue for us.
Right. He doesn't want a trial in this case. That's the issue. He doesn't want a trial in this case. The Judge Barbas had this set up for a trial, and he said, I don't want a trial. I'm going to get rid of all these fact issues because of this.
We both stipulate to the critical facts.
Right.
That's a policy interpretation.
That is correct.
And it all hinges on the return to work aspect, doesn't it? Was he able to return to work, and is that a game changer, or is that an exclusion as a matter of law?
I think, Your Honor, Judge Valenti, I think when he stipulated that he could return to work, I do think that was dispositive. Yes, sir, I do.
Okay.
And it was because once he says, I can return to work, the insured is no longer disabled, and the benefits end by the definition of benefit term under the definitions of the policy. If you follow his theory to its logical conclusion, and you say, okay, I only have to show that I went out of work originally because of a medical disability, and that's it. I don't have to continue to prove that I remain currently medically disabled. I don't have to continue proof of loss, any of that stuff. Then let's see what becomes inoperative in this policy. The policy says that you have the sickness for which you are disabled requires that you receive regular care by a physician. Why would that matter if all that mattered was the original onset event? The policy says that the insurance company has a right to have you medically examined. Why would that matter if your medical disability beyond the initial date was the only thing that was relevant?
I think that argument has some strong consideration because it seems to be undergirding the federal opinion in the Royal case out of Georgia, I believe it was.
Yes, sir. Yes, sir.
And in that case, the trial judge applied Georgia's laws of contract construction, said the total and the residual are two separate provisions. The rider adds another provision and goes through, that you have to take your application. You got to look at the other, as you mentioned, the periods of disability.
Right.
And without, I'd read that case since that was prompting some of my questions, and it seems to me that this case is consistent with your argument, which is why you cited it, obviously. But
right. Yes, sir. Exactly. I think
it's New York and it's Paul Revere.
It's a continuing obligation to provide proof of loss, so the insurance company, continues to be able to evaluate the ongoing claim. That's why these benefits are paid monthly, and they're not just put on some sort of perpetual track.
And if it's supposed to be an income replacement, one would say, well, that means we have to replace the income that you're not getting, arguably, by working or being capable of working. The cases seem to talk about as a result of your employment, which, depending on which time sense used, which temporal point you look at, ever or then, could help the analytical.
And it was either the Litton case, Your Honor, or the Harvey case that was cited in our briefs, where the court talks about there in those cases you had two insureds that were not working, just like this case. And in various degrees, they argued essentially the same thing. Under the residual disability provision, I do not have to work. And both of those courts said, that's not how you read these. That's not how these policies work. That's not what they were designed to protect. They are policies designed they're disability policies. I think the title says it all. If you cannot work due to a medical impairment, then you are entitled to benefits under the total disability provision.
There's a passage in Litton that talks about that the purpose of disability income is to replace income. The provisions must be read to give effect to the income replacement purposes. Reading the policy definitions with that intent could only allow for interpretation that the insured was required to be in an occupation for which he was receiving income when he became disabled. It's undisputed the plaintiff was not engaged, and I think that's the point you are directing us to.
The court goes on to say, Your Honor, Judge Casanova, it says, unlike when the insured is totally disabled, the insured would still be earning income, and thus would only be entitled to a proportionate amount of the benefit to replace the lost earnings, and that's what we're getting at with the residual disability provision. That the court was construing the residual disability provision. In that case, that was an insurance agent who wasn't working and still claimed, I'm not working, but I'm still entitled to the benefit. And the court said no. If their theory, if their theory was so sound, surely there would be at least one case in the hundreds or thousands of cases that have looked at these policies across the United States that would support it. They have not cited one case. We've cited at least 4 cases where you have at least analogous facts where the courts have said, no way, this is not what these residual disability clauses are about. So we would ask that because the plaintiff in this case has voluntarily waived his right to a jury and doesn't want a jury, we would ask that the court would affirm.
The difficulty in some of those cases is the argument could be made that the judge is writing at least part of a term, if not all terms, said, you must go back to work in order to have this benefit. Now, the cases seem to refute that notion by saying it's assumed that's what the purpose of this insurance is for. It's to maintain your income from working and the loss of work. But let's just go back to the first point. What would be your contention that the requirement to work, because I think their contention is you should have written it in. Why do you believe that this policy can be interpreted such a way as to relieve your client of that duty?
Because of all of the provisions in there that talk about current income, loss of income, all of those terms, Judge Casanova, are used in their positive normative sense. They're not if clauses. They're not conditional. They're saying, we will take a look at your loss of income based on your current income. He made a remark, I'm not sure if it was accidental, about, well, it doesn't say anything about income. There's about 5 paragraphs where it does nothing but talk about income. You read those things out of the policy if they have no operative effect. When it talks about current income for personal services, what else would it mean? It's a little bit baffling. I do admit to some frustration trying to understand their arguments. But this notion that I was disabled in November 1, 2010, and therefore in perpetuity you must pay me, finds no support in any Florida statute or Florida case or any other case in the United States.
If the argument is in perpetuity, your response would be, this would be almost like Social Security disability. We will pay you once you have it, and you're not fit for gainful employment, rather than an income replacement policy for disability insurance.
Where you have to have a periodic proof of loss.
Your first one is that but you have a total disability, which would require you to pay in perpetuity, right?
Until the disability lives, yes.
As long as the moderating effects are going.
Yes, that's exactly right.
As long as they make the application and you can do your auditing.
And continue to go to see a doctor on a regular basis. Florida law also, and it's cited in the Mack case that we cited in our brief, Florida law says the insured has a duty to relieve him or herself of the disability. These policies, the notion of these policies are one-shot only policies that once there's a disability, it stays a disability. That is nowhere to be found in this policy. Their theory, their argument, that this policy was designed to provide a total disability benefit when you can't work, followed by a residual disability benefit when you are able to work, finds no support in the language of this policy. That's nowhere in there. And I would challenge them to point that out. If there are no further questions, I would ask the court to affirm. And thank you for your time.
Thank you.
I'll try and hit on a few of the points there, Judge Casanova, that you had asked about.
Well, I read some of those cases, and please enlighten me, your view of them.
Yeah, you had also asked about whether he is disabled. I just want to say the record does reflect that that Mr. Bagge is presently seeing a psychiatrist. He's been prescribed antidepressive medicine. He still is under treatment for the depression.
Does our record indicate whether or not a doctor has released him to go back and seek gainful employment, or is that covered by the stipulation?
That's covered by the stipulation. I'm not sure that he believes that he's ready to go back to work, but it was a procedural mechanism to get the case to
arrive here, to determine
Correct.
how the policy is to be interpreted.
Right. I think there's this question as to whether this is an insurable interest. Why was a policy written this way? I think it's a very legitimate concern that Mr. Bagge and others like him would have had. What if I have a disability and then I can't go back to work? What if there's no market for me after a disability? What if the economy is turned down like in 2006 and lawyers were looking for jobs everywhere? What if nobody wants to hire an aging lawyer with a history of depression for a job? It's a legitimate insurable interest that was of interest to him when he purchased the policy and was marketed by New York Life as such. To be clear, the record shows there was no separate application for residual disability in this case. And I think when you read the policy, it makes sense because religion... Sure.
You just made a very interesting argument about what if the marketplace, et cetera. Is that answered in the very first part of the rider where it says, the loss of income must result directly and apart from any other cause, must result from an injury or sickness as defined. If there's any other cause of loss, that would suggest it didn't result solely from the injury and he wouldn't get the residual benefit. So is that language going to be operational in that situation if there's a market downturn, if I'm reading it correctly?
Well,
and again, I'm new with this electronic records. I just photocopied.
We would say that any other cause, the plain meaning of any other cause is the cause of the loss of income. And there's a distinction that we make in our brief between a loss of his income and a failure to replace income, right? There's a distinction to be made there. The original cause of the loss of his income was solely the disability which caused him to lose his job. At any point after that, if you accept the proposition that you have to evaluate cause every time, the cause is always going to be, well, you didn't get a job. That's why now you don't have, that doesn't make sense, right? There would never be coverage under residual disability if the cause was you didn't get replacement income, you didn't get a new job. And that's part of the problem with the argument that's being made about this monthly evaluation. If it's a monthly evaluation, I'm not sure whether we agree there's a monthly evaluation as to amount of income. But if the court, if the company has to evaluate every month, does that mean he's subject to medical evaluations every month? Does that mean that he has to meet some, and what are the standards? How sick do you have to be to get residual disability coverage? How hard do you have to be looking for a job? Right? None of that is addressed in the policy, which is why the reason it's not there is because that's not what the standard is. What is the policy language? The policy language says that after an incident of total disability, if you have at least a 20% loss of income following a covered illness or injury, you are covered. You're covered for the term of the policy until you're 65. Again, the reason there's no separate application for residual disability is because there's really no application to be made. You've qualified because you've had this total disability that's qualified you for coverage. The only thing left is to make a determination that you're making at least 20% less, that your income is 20% less. There's no further medical evaluation. We don't even need to, go down that road. Mr. Tolan was making an argument about the benefit term. I will be honest with you, I didn't quite follow it. The Florida Supreme Court has said you shouldn't have to be a Philadelphia lawyer to understand an insurance policy, and I think that's where we're getting with the explanations by New York Life as to how you figure out what this policy means get so convoluted that it's difficult for the five of us in this room to follow, to track the language and figure out exactly what the standards are. I think it comes down to this. If that's what we have to look at, if we have to survey all the cases to figure out what this policy means, if we have to really dig into this, the policy may be ambiguous. If the court believes it's ambiguous, then the presumptions have to fall in our favor. The court has to interpret in a way that is strictly against the insurer, liberally in favor of the insured, in a way to design, or to effect the most coverage. And ultimately, I think that is the end game, is that if the policy is that hard for all of us to figure out, an insured like Mr. Bagge who's shopping for an insurance policy is never going to figure it out. That's not what the courts intend, and ultimately that ambiguity has to be resolved in our favor. So we would ask that ultimately that the summary judgment below be reversed and the case be remanded for further proceedings.
Thank you.
Thank you.
both.